Hi, and welcome to yourusvisa.com, where we provide you the immigration news and much more. Today, deportations and the 10-year rule, or the 10-year bar. Today, we're taking a little moment to talk about a topic that comes up a lot in our questions that we receive daily at our office. Many people tell us that they have been deported, and then they ask us, when can I come back? How do I get my benefits or my rights back? How do I do this? So, let me explain to you how this process works. If you have been deported from the United States of America, you probably have seen a judge or have seen an immigration officer or have seen somebody that has looked at your case and has determined that you're not eligible to be in the United States, and as a consequence has deported you. That order of deportation in some instances can be from 1 year to 5 years or even up to 10 years. Most orders of deportation today are 10 years. If the orders came from a longer time ago, they were 5. If it's expedited removal, it could be 1 or 5. There are different types of deportation orders. And based on the order that you receive, you should know or should have known when it happened, how long that bar is for you in particular. For example, there are certain types of deportation that occur as a result of an aggravated felony. If that's the case involving drugs, your bar is probably forever. Other cases, like a fraud on immigration, are also forever. There are no pardons, there are no waivers. So in reality, you have to know the day you got deported, how long is your deportation for? Now, what can you do in order to come back earlier than the punishment that you have received for the quote-unquote violation of the law that you committed? And that is what I'm going to explain to you on how to do. In order to obtain re-entry after deportation, there is an application that needs to be done. It's called re-entry after deportation. And there's also a form called a waiver, a pardon of some kind. Both of these applications have to be done in order for you to re-enter the country. However, that re-entry into the country does not come by itself. In other words, you cannot file these applications without having an immigration benefit that allows you to enter the United States. For example, a tourist visa to visit a family member that is ill and dying. For example, a work visa. Another example, a United States citizen is your spouse or is a child over the age of 21 who can sponsor you. Any type of visa that you are trying to use to re-enter the country would have to go attached with the permission to re-entry after deportation and the waiver of your excludable crimes or your admissibility crimes. Once you file the application, the process takes about 1 year. Depending on the jurisdiction, it usually is done inside the United States together with the application for relief that you're looking to use to enter the country. Example, United States citizen has a spouse. The spouse was deported. For X, Y, or Z reason, she could not obtain the benefit of residency inside the United States, like she entered illegally into the country and was not protected under Section 245I, which allowed her to do her green card in the country. So she got deported and she has to do her green card abroad. Okay, when she files for the petition from the husband asking for the spouse who is abroad, she also files the waiver and the permission to re-enter after deportation. Once those processes are approved, if approved, then she can continue to the process of residency at the embassy, obtain her green card, re-enter, and she regains all of her ability as a green card holder. It's like the order of deportation never existed. However, this process is one that is complicated, very complex, and very hard to obtain. It is discretionary on the part of an officer who is seeing a bad record in you, in that you committed a civil offense or a criminal offense, and he's going to weigh that versus the factors of why you should return. I have a husband that's a United States citizen for family unity. I have a child who is ill and needs my care. I have to go visit my grandma who's dying. And he's going to weigh that and determine, based on that, whether or not you should receive this pardon. Obviously, the more time that has passed since the day you got deported, closer to the 10 years in your bar, your likelihood of success goes up because the factors outweigh each other. But this process is complex, should not be done by yourself, and is very costly. However, trying it depends on whether you want to take the risk of the loss, and mostly it's an economic loss because you're going to be paying somebody to process this paperwork for you, which is going to be expensive. Does it outweigh the waiting period that you have on your order of deportation? These are the things that you need to consider when trying to re-enter the country prior to your 10-year bar, if that's what you have on your deportation order. Also remember, the factors that you have must outweigh the crime or the civil infraction that you committed and allow the officer to make a good decision on your behalf. It is totally discretionary. You are already outside the country and you've already seen due process in your case. Remember that when you are deported, you have lost the benefits that you previously had. For example, you were a resident. When you're deported, you're no longer a resident. So you have to start from scratch. You have to start the whole process again. The petition, the residency, and the pardons. It is not like you're going to recover something that you previously had. This and much more here at yourusvisa.com.